Joakim, the 2017 Annual Surveillance report was recently published, and in that there are descriptions of disciplinary cases. Some of them relate to issuers' disclosure obligations. Can you say a few words about some of those cases?
Yes, of course. I mean, we're typically happy to talk about such cases, not necessarily because we want to bring attention to them, but because they're important to help companies determine where the borderline is drawn and how to accurately apply regulation. So yes, we're happy to talk about that, and as said, not to attract attention to the companies that were involved in the respective cases, but to help all other companies comply with regulation and become more comfortable in applying regulation.
So disclosure obligations relate to inside information, and I guess the first challenge for companies is to determine when inside information exists in the first place, right?
Absolutely, and that is, as you say, rightfully so. It is and can be a challenge. Not all of those determinations are simple to make. This case was about a tricky situation where the CEO of SEB decided to leave the company, and the company made the interpretation that inside information about that event arose on a Saturday when a board meeting was held to discuss and conclude on that matter, and the bank then decided to disclose the matter on Monday morning. Inside information, however, can arise before a process is finalized. It can, for example, arise at a certain point in time when it is likely enough that a certain situation will appear, although it hasn't finally appeared. A negotiation doesn't have to be finalized. The ink doesn't have to be dry on an agreement, for example. So when there is material prospects that something will occur, when it is likely that something will occur, then inside information then can be considered to exist. And in this case, the disciplinary committee concluded that at the latest, inside information existed when the company decided to summon the board meeting to discuss and resolve this matter.
So the definition of inside information is tricky, and hopefully case practice in this area will help to create some additional clarity. But does the mere fact that the company has established that inside information exists also mean that the company has to disclose that information?
No, it doesn't, and I think that's an interesting aspect and an important one, because I mean, the basic rule is obviously that inside information should be disclosed as soon as possible, but there are possibilities in certain situations to delay the disclosure. The company, in order to be able to do that, however, needs to determine that three conditions are met at the time of taking the decision and also continuously until the point in time when the information no longer then constitutes inside information or when the company makes the information public. And the three conditions is that the immediate disclosure of the information would harm the legitimate interests of the company. The second condition is that delaying disclosure of the information would not mislead the public or would not risk misleading the public. And the third condition is that the company has to ensure that it can contain the information confidential until the point in time when it makes it public.
And at least one of the cases from last year was on this topic.
Yes, absolutely. The so-called Hexagon case was about that specific part of the regulation. And for those who don't recall, the case was about the situation where the CEO of the company was detained. He was taken in custody by the police. And that happened on a certain day, and the company then decided at that point in time, and I believe rightfully so, that the information constituted inside information. It decided, however, to delay publication of the information, and the legitimate reason for doing so, or the legitimate interest that it would consider to be harmed, was that it regarded the information to be unclear, or unclear to the extent that it couldn't make it public, that it couldn't accurately inform the investors about what had actually happened. And while that is true in my view, you can have situations where you don't have sufficient information to be able to disclose something. And that's a challenge I think companies face in many of these situations. In this particular case, however, the disciplinary committee concluded that the company actually had sufficient information. It had received written documentation from the police about the reasons for the detainment and the actual transactions for which there were suspicions of wrongdoing. So while that was obviously a very uncomfortable situation for the company, and they were working hard to influence the outcome and to provide argumentation that would hopefully change the actual outcome, at that point in time, they actually had sufficient information to inform the public about what was the situation at that point in time. They could then make further announcement if developments would progress in a certain direction, but they did not have a reason not to disclose the information.
No. So are there any other aspects of upholding disclosure requirements on the MAR that has been in focus during the past year, or that you otherwise would like to mention?
Yes, absolutely. I mean, the one area that I think has had the most direct impact on companies and on all companies, not only those that have found themselves in as tricky situations as the one we've just talked about, is that MAR requires more structure and discipline when you apply it than perhaps previous regulation did. At least that's something that we often hear from companies and from advisors to companies. Not only do you need to make sure that you make the right decision and take it at the right time, but you also need to uphold a certain level of documentation for those decisions.
Thank you very much, Joakim.
Thank you.
Rewrite tomorrow.